Well, good afternoon. I would like to start off by talking about bail matters. As many of you know, there was an Arnold Foundation study that was done a number of years ago. Okay, sorry.
I'm fine.
I'm sorry. Everybody good? Okay. Okay. Let me start off by talking about some issues regarding bail. In 2015, Arizona's court system adopted changes to how judges assess conditions for individuals released, arrested, and seeking release for criminal charges. Per Arizona law, in determining the method of release or the amount of bail, a judicial officer, on the basis of available information, shall take into account a variety of factors, including the following: the views of the victim, the nature and circumstances of the offense, whether the accused has a prior arrest or conviction for a serious offense or violent or aggravated felony, or an arrest and conviction in another state that would be the same, evidence that the accused poses a danger to others in the community, the results of a risk or lethality assessment in a domestic violence charge that's presented to the court, the weight of the evidence, the accused family ties, employment, financial resources, character, and mental condition, and the results of any drug tests submitted to the court, whether the accused is using any substance, the length of his residence in the community, records of arrests and convictions, record of appearance at court proceedings or a flight, whether the accused has entered or remained in the United States illegally, and whether the accused residence is actually in this state or another. These items are to be reviewed by pretrial services. The Arizona Court of Judicial Administration has required the use of a pretrial risk assessment tool in the Superior Court since 2014. Prosecutors and law enforcement also provide information to the court, as can defense attorneys, for consideration when addressing release conditions. While I firmly believe that we should release individuals pending trial who do not pose a danger to the community, who will appear in court and remain crime-free pending the resolution of their case, we must impose conditions necessary to keep others from absconding or from presenting a danger to our community. But the tool being used by the courts is called the Arnold Foundation Pretrial Risk Assessment Tool, and it has not had significant evaluation since its adoption. On October 7th, 2022, the Arizona Association of Chiefs of Police and the Arizona County Attorney and Sheriff's Association sent a letter to the Arizona Supreme Court Justice Brutinel requesting a meeting and a committee to reevaluate the risk assessment tool and format of the current Form 4 document. Today I'm announcing that the Maricopa County Attorney's Office will be joining this effort in asking for a review of this risk assessment tool. Every day, prosecutors from my office review cases set for initial appearance in front of the court. We provide many items that I referenced earlier for the court to consider when determining release conditions. But information gathered from pretrial services and provided to the judicial officer sometimes has conflicting recommendations, resulting in release conditions that may not keep the community safe. And I have several instances of anecdotal information that I can share where this has occurred in cases currently being prosecuted by my office. In May 2021, a defendant was stopped for DUI and officers found dangerous drugs and a fully automatic pistol in his vehicle. The defendant also posted a message on social media of himself with an AK-47 with a message that he was going to, quote, RIP, the next cop he encountered. While executing a search warrant of his home, law enforcement located additional drugs for sale and several more firearms, including another fully automatic Glock pistol. The defendant was a prohibited possessor based on his considerable criminal history, including armed robbery and kidnapping. And yet he was released with the only condition being that he report to pretrial services. There was no bond. In July of this year, a defendant was arrested for sexual exploitation of a minor after a Department of Homeland Security investigation found him to be participating in the exchange of child pornography via the internet to social media apps. A search of his residence located hundreds of images of child sexual abuse media. The defendant was released on his own recognizance without electronic monitoring, which is actually required by the statute. And I want to be very clear here. This is not an indictment at all of the court system. It is difficult in deciding release conditions, and the courts do a very good job and are very available to listen to the recommendations of my office. This is a call for the tool to be reassessed, and we want to work with the courts in doing that. These are merely examples that lead us to be concerned about the efficacy of a tool developed by the Arnold Foundation study. As it stands today, prosecution and law enforcement resources, of course, are at historical lows. So keeping this community safe is a priority, but it becomes significantly more difficult when appropriate release conditions are not being recommended by the tool. Non-appearance at court hearings by defendants slows efforts to seek justice for victims, and it taxes law enforcement, who must now arrest individuals a second time for bench warrants issued when a defendant does not show up for court. In the worst of cases, it can mean that someone commits another offense, subjecting another innocent person in this community to a criminal act. So as county attorney, I want to work with the courts, law enforcement, and other stakeholders to engage in a discussion and review of the tools Arizona uses to keep our community safe, while protecting the rights of defendants when they are accused of a crime. The other thing I want to announce is that we have another catalytic converter etching event in Scottsdale this Sunday from 9 to 4. The address is 2428 North Scottsdale Road. And we are partnering with Scottsdale Police Department as well as Midas to provide this. So before I go on to any other questions that you all might have, do you have any questions about either the catalytic converter etching event or the discussion I have just had about bail? Yes, sir.
The reassessment that you're seeking, are you going to offer a replacement? Is there something that you would prefer instead of the model that's being used?
I think what we want first to do is just evaluate the efficacy and see if there are factors that are not being taken into account with that tool that need to be added to it, or if things need to be taken out. So I think we need to start with the tool and move out from there.
Anything that you want taken out as of now?
I want to see the effectiveness of each of those prongs before I start just removing things. This needs to be evidence-based. It's not what I like and what I don't. It's what evidence shows that is important to me. Yes?
So there was a recent case of a woman who was involved in an officer-involved shooting. She was shot at when she rammed her car into them.
Mm-hmm.
It turns out she had a very similar incident, October 1st, less than a month, where she rammed her car into police officers' vehicles. She was arrested, went out on bond. I mean, and it happened twice in less than a month. For a situation like this, I mean, what is the situation? I mean, how does something like this happen?
Well, I need to correct some of the facts that you just stated there. What happened was when somebody is arrested, they have to receive their initial appearance within 24 hours. And because I believe she was taken to the hospital, there was a delay after there was some delay after the first incident. She did not receive her initial appearance within 24 hours. That resulted in the release. But the case is before our office right now, and we are reviewing it for charges. Any other? Hold on, I'm getting. Okay. Hold on a second. Any other questions? That's it? Huh?
General?
Okay.
Can you please provide an update on the administrative investigation of the prosecutor who was put on leave over the alleged relationship with a detective?
Mhm.
And that prosecutor's on administrative leave. How much are they being paid to sit at home right now?
That prosecutor is on administrative leave. It is paid administrative leave, so it is her regular salary. I have ordered an investigation to be done. That investigation is ongoing. And, you know, as soon as I get it back, I will take appropriate steps.
You don't have an estimated date of completion?
I don't. I know that one of the people that we wanted to talk to has been out of the country. So that's certainly delayed us a bit.
And her salary?
I'd have to look that up.
Any other questions?
Okay, yeah, go ahead.
Charles Ryan was scheduled for trial this week.
Mm-hmm.
It was not. It did not go forward.
Mhm.
I believe his next trial date tentatively is Election Day. Are you confident that a trial will go forward then?
You know, having been a trial attorney for many years, I would never say I'm confident about a trial going forward on that day. But what I would say is this. There are a lot of things that go into scheduling a trial. That includes witness availability, attorneys on both sides, as well as the availability of a court. And if those things come together, then hopefully that will go forward.
Has a plea agreement been offered to Mr. Ryan?
I can't speak to that. That's an ongoing case. Yes, ma'am.
Can you talk a little bit about Randy Kaufman's sexual indecency case that's been referred over?
Yeah, we haven't received that submittal in our office yet, but I am aware of it. I also wanted to point out that there was some erroneous information published about that said that there was a clerical error on the part of my office. We actually looked into that. It was actually a clerical error that occurred between the agency and the court system. It was not involving the Maricopa County Attorney's Office. I do want to correct one thing. I said had not received their initial appearance. The case was not submitted to us within the 24 hour, within the time frame that we needed in order to file it and keep it the release conditions
This is
in
regards
place.
to the.
Yeah, the Gilbert case.
So we're going to say it one more time for me. So what?
So they have to receive their IA within 24 hours. Then they have to have charges filed within 48 hours. It wasn't submitted to us in a timely manner that we could file those charges within that time constraint. But it has been submitted to us now. We are reviewing it for charges as well.
So that resulted in the release.
Yes.
Initially.
Yes.
With the okay.
Yes. Is that it? You're not going to make me do math today?
No, I was going to see if you wanted to ask me to do math. Now we can see a car crash for real, right?